Good afternoon. We're on the record S-1-SC-40573, petition for writ of superintendent control, Stewart versus Ramczyk. Of entry of appearance by petitioner. You have 17 minutes. You may proceed.
Good afternoon, Mr. Chief Justice and members of the court, and may it please the court. Petitioner Senator Mimi Stewart requests that this court grant her petition and exercise its superintendent control over the district court, reversing the decision to deny her motion to dismiss on legislative immunity grounds. We're requesting that the court remand the case back to the district court with instructions to dismiss the case with prejudice on the basis that she is entitled to absolute legislative immunity. Senator Stewart is the president pro tem of the New Mexico State Senate. She was elected in that role by other members of the state Senate. In that capacity, she is the co-head of the legislative branch of the New Mexico government. She is also tasked with preserving order and decorum in the state Senate and deciding all questions of procedure and order. Mr. Candelaria, the real party in interest to this petition, alleges in his lawsuit that Senator Stewart took alleged retaliatory actions against him when she reassigned the location of his seat on the Senate floor and reassigned his office location in the roundhouse to, as the complaint alleges, less desirable location. He alleges that these were adversarial actions. In other words, that they impacted his ability to legislate.
This is alleged as a Human Rights Act violation.
It is alleged as a Human Rights Act violation, yes.
And I really want it, because our time is very limited. And I have questions from both sides as to this particular issue. I'm really trying to explore the limits of legislative immunity, because it seems to me that the position that you're taking is that there is no possible way to ever kind of look behind the veil. As long as a legislator says, this is in my normal course of my duties, assigning offices, I don't get to look behind that. And there's case law that says we don't look at motive and intent. But there has to be some limitation on that, because if I take a different example than a Human Rights Act violation, what if it's quid pro quo sexual harassment? I'll give you this sweetheart office, or I'm going to give you this really crummy office, however that's just defined, unless you are going to engage in sexual activity with me. It's about assignment of office, but it's not. And I think that's the nature of Mr. Candelaria's complaint here. And I'm wondering, how do we test the limits of that? And that's, I'm really struggling with it.
Yeah, so as we pointed out in the briefing, the legislative immunity, it doesn't apply to all acts the legislature needs to because they're an elected legislator. There's case authority that says, for instance, that taking unlawful activity is not considered.
It isn't a violation of the Human Rights Act. Unlawful, I mean, it's alleged at this point, but isn't that likewise unlawful activity? So how do we deal with that if we're just going to say, nope, there is an absolute bar to even making the inquiry?
I think that's a potential issue with Mr. Candelaria's claims here. And we had argued in the lower court that there's no employee-employer relationship, that there's not an actual Human Rights Act claim here. But notwithstanding that, that's not the issue we're here on. But I think it's a good example of when you have a Human Rights Act violation, it's typically an employer-employee relationship. There was no employee-employer relationship here. I think that would be considered outside of the scope under that framework that we talked about.
But what about the sexual harassment example? Because you can sexually harass your colleagues that are co-equal, legislator to legislator.
I think that
how do we deal with that and write something that's consistent, that gives limits or some definition to that which is out of bounds, like bribery is clearly out of bounds? Why wouldn't sexual harassment be out of bounds?
It's because that when we're looking at the objective action, so I think when we're looking at the analysis in the legislative immunity framework is to look at the objective action. whether it's moving the office. I think when we're looking at your example, it's looking at something else. We're not just looking at moving someone's office. We're looking at the action, the objective action of their sexual harassment. What's before the court today. We can look at the objective action of Senator Stewart moving another senator's office to a less desirable location, or moving
As part and parcel of her role as the leader of the Senate.
Exactly.
And we would never, no matter what, then, but wouldn't we be left, and this is all testing limits, and I'm going to push over here too. Aren't we saying that, that a legislator could always cloak their activity? And this is part of my job. So, and I'm not suggesting, I'm not weighing in on the facts here at all, but using my sexual harassment example again, the legislator who engaged in quid pro quo activity could always say, well, it's part of my job to assign offices. We're never going to look at what my intent was.
And going back, when we look at what is considered a legislative action or an administrative action, for instance, under federal case authority, the administrative actions are primarily focused on, do these impact an employee, which is typically where we would see.
Yeah, there's a lot of HR cases.
The employee in HR cases, which are employee-employer relationships. And the federal precedent has weighed in on that and has said that those things are not objectively legislative activities. It's different here, where you have the President Pro Tem of the Senate acting in her capacity to reassign seats on the Senate floor, reallocate office space. Those are legitimate legislative activities. And Mr. Candelaria is really seeking to have the judiciary look at and tell the co-equal legislative branch of government that, no, you don't get to decide, that the President Pro Tem doesn't get to decide where senators sit.
So for Justice Bacon's example, would the legislator get immunity? Because it's legislator 1 sexually harassing legislator 2 to get whatever office space might be ideal.
It's a tricky hypothetical, for sure. And when it's one, maybe, which is, so it's one legislature against another legislator. I think there are arguments that legislator who assigned the offices, because we're looking at the objective action, could be entitled to legislative immunity. On the other hand, if
so are we saying
we're
looking at the action, and it doesn't matter if it was done for a really horrible reason or a perfectly reasonable reason. It's about the power that that person holds generally to make the decision.
That's what the federal case authority, that's where it goes, that it says we can't look at the motive and intent. And I think this example is telling us that we would have to look at the motive and intent behind why that office was assigned.
What if the motive is objective? What if they said, I'm moving you because you're protected class X? Would that be sufficient? And, well, let me ask you that first. I am moving your office because you're a member of protected class X.
When we're talking about moving legislators' offices, I think it's still legislative immunity applies. And when I say that,
hold on, even in that circumstance,
where they've objectively said, I'm moving you.
yes.
I think there is an argument that legislative immunity applies. And when I say that, I'm not endorsing those actions.
No, I know.
And I'm not saying that legislators should be doing those things. What I'm saying is that it's not up to the judiciary to intervene in those actions. That when we're looking at legitimate legislative activities, we have to look at it, the objective action. So here, and it is alleged here that Mr. Candelaria's seat on the Senate floor in his office was reassigned for not legitimate reasons, but to ask the court to do that is asking the court to look at the motives and intent behind those legitimate legislative activities.
Justice Morrison.
Oh, I was just wondering the same hypothetical, but it was a bribe. We know that you can't do that.
But a bribe is objectively not a legitimate legislative activity.
Neither is sexual harassment or racial discrimination. I mean, I'm thinking of the United States Congress right now saying we're not going to provide a bathroom to the trans community. Is that a legitimate legislative action? It's not going to come to us, but it's that kind of thing, like deciding office space can be, it feels like it can be an eraser almost, or magic language to cover up things that are really not legitimate.
Right. And I want to be clear, I don't think that the sexual harassment itself or the racial animus is protected legislative action. But if we're looking, if the action is you moved my office, you moved my seat on the Senate floor, that is objectively related. That's within the sphere of legitimate legislative activity. And I think these examples, as opposed to the bribery example, would require the court to look and examine the motive and intent of the legislative action, which is improper.
So in the hypothetical, the sexual harassment hypothetical, the legislator could sue being sexually harassed, but could not sue for getting their office not reassigned or reassigned.
Yes, and I think those are the
That's what you're
guideposts that
suggesting.
we're looking at here, that if the lawsuit is you sexually harassed me, that's not legitimate legislative activity. But if the lawsuit is you moved my office, the quid pro quo example, when we're looking at the action, I mean, here it's a retaliation claim.
That's the element. Moving the office is the element, the retaliatory action.
Moving the office is the retaliatory action. So we have to look at that action objectively.
Okay, but in senior justice's scenario, sexual harassment, you're saying is not legislative, legitimate legislative function. But if the retaliatory prong of that is moving the office, is that then cloaked in immunity?
I think that is cloaked in immunity.
So it could not be, it could not be considered a retaliatory action. Is that the argument?
That's the moving of the office is where the legislative immunity comes in and where it attaches, because those are part of the legislative deliberative process. And I think these examples would require the judicial system to look into the judiciary to examine the motive and intent. If the claim is you retaliated against me and the retaliation was motivated by racial animus or sexual harassment, then that's requiring or asking the court to examine the motive and intent. And that is a clear error. Every immunity undergoes that framework where you're not supposed to look at the intent and motive behind the action. We're supposed to look at the objective action. And here it is moving the seat on the Senate floor of another state senator.
So where's the line between a legislative duty or task and an administrative duty or task? Where is that line? Because that seems blurry for me in the case law.
Yeah, it is a little confusing in the federal case law. So the administrative action is really a term of art in the legislative immunity framework. It is not, I think, as we would maybe think. I think administrative is sort of a misnomer, because it's not about managing the internal affairs of the legislature. It is about doing things that are outside the sphere of legislative activities. So the federal precedent primarily focuses on employment decisions and other issues that impact a single member of the public. So for instance, an employment decision terminating a legislative employee, I mean, that happens in the judiciary, that they terminate employees. That happens in the executive branch. That's not just solely integral to the legislative process. Whereas there is case law that says there is legislative immunity for actions taken to, for instance, expel members from like caucuses, from the House. Those are actions that are objectively within the sphere of legitimate legislative actions. So legislative immunity would attach, as opposed to the administrative actions, which are employment decisions.
So would any action against another legislator be protected by legislative immunity? Would it constitute a legislative action?
It has to be integral to the legislative process. So I think here, these are clearly objectively decisions that should fall squarely within the legislative branch.
It's akin to assigning people to committees.
It's akin to assigning people to committees. It would be akin to the legislature trying to say where you all could sit on the bench. Those are things that each co-equal branch of government gets to decide.
What we struggle with, I think, is whose form of objective, right? So you say fairly, it's not a criticism, it's what we're struggling with. You say, this is about moving offices, this is administrative. The complainant says that's pretextual, to put it in the world we know. That's pretextual. It has to do with racial animus or sexual harassment. And the court here says, let's figure that out by discovery.
Yeah.
And then the immunity cloak comes up and we're not even getting to that. So how do we resolve that?
Well, I think first we can look to federal precedent because there is a good body of law that talks about what is integral to the legislative process. And there's no federal precedent that says actions taken by one legislator against another legislator are outside the sphere of legitimate legislative activity. So I think there's probably some examples that you could have an action against one legislator against another. But when we're talking about the internal working of the legislative branch of government, then those things objectively here, reassigning seats on the Senate floor, reassigning office space, allocating resources, those are things that, supported by federal case law, are objectively legislative, integral to the legislative process.
We'll extend some of your time and we'll extend it to Mr. Candelaria because I want everybody to be able to ask questions here. But you talk about rely on federal cases, that relies on the federal Constitution. One of the questions I need answered is, there are allegations under the New Mexico Constitution. I understand the language is similar. My question is, would there be any ability of this court to come to a determination different from application of the federal Constitution? And let me ask you that.
So the New Mexico Constitution is framed after the U.S. Constitution speech and debate clause. They are effectively identical, other than there's an additional phrase in the New Mexico Constitution that says, or for any vote cast in either house. So I think that the New Mexico drafters clearly intended that New Mexico follow the U.S. Constitution speech and debate clause, and even added clarifying, I think it can be considered expansive language in the New Mexico Constitution speech and debate clause.
If a state passes a Human Rights Act claim like New Mexico has, does that signal that immunity inures to the benefit of the legislator or the complaining party? I think it probably always inures to the legislator. But does the passage of a Human Rights Act at all complicate that analysis?
No, I don't believe so, because, first, the speech and debate clause, this is something that's a holdover from, pre this country being founded.
It stems from common law.
It stems from common law. It was written into the Articles of Confederation, the U.S. Constitution, and then our drafters.
Or the 14th Amendment?
But our drafters here in New
Civil Rights Act?
Mexico, right, yeah, but our drafters in New Mexico drafted it clearly intending for it to be identical. And I don't see any reason to diverge from federal law.
Hold on one moment. Let me make sure everybody has.
Not yet.
We have time. Okay. Thank you, counsel.
Thank you.
And Larry? And Larry, you have 13 minutes. We'll extend a couple of minutes. Okay.
Buenas tardes, su señoría, and it please the court, and good afternoon, Mr. Chief Justice. Moment of clarification. The underlying claim, just to bring us back, is a retaliation claim. And I appreciate the court's struggle in setting an appropriate line for the scope of legislative immunity, because I, as the real party in interest, agree with the sentiment that this legislative immunity cannot be boundless. While interpreted broadly, it is certainly not coterminous with the executive immunity under the federal constitution, which is extended to the president, which extends to the outer bounds of any official act taken by the president. I believe, and I'll end here and then dedicate the majority of time to questions, is the appropriate inquiry, the appropriate test that this court should adopt was articulated by the Supreme Court of the United States and adopted and applied by the 10th Circuit, showing Gravel at the U.S. Supreme Court level and then at Bastion, which we argue in our briefing. They articulate a very clear test that I believe strikes the appropriate balance between allowing legislators to engage in official legislative acts for which they are entitled to immunity, and the notion that no person, no matter how powerful, is above the law in this country. So I'll end my opening by citing to the Bastion decision, which I think articulates the case this court should adopt. The test this court should adopt, you're not required to. Chief Justice Thompson, I believe this court could fashion whatever inquiry it wished, but I think this federal precedent does strike the right balance. The court notes in Gravel and quoted in Bastion that senators generally perform certain acts in their official capacity as senators does not necessarily make all such acts legislative in nature. And I think that's where the rub is here. And the court goes on. Legislative acts are not all encompassing. The heart of the clause is speech or debate in either house. Insofar as the clause is construed to reach other matters, they must, quote, be an integral part of the deliberative and communicative process by which members participate in committee and House proceedings with respect to the consideration and passage or rejection of proposed legislation or respect to other matters which the Constitution places within the jurisdiction of either House. Here, there is no action taken by other House. This is alleged retaliatory to action taken by one member, not in the context of a legislative committee meeting, not in the context of a legislative session or proceeding on the Senate floor, not executing.
I'm not sure I agree with you at all on that view of what the president pro tem's job is. She has a different job than the line legislator. I think there's no question about that. She is the co-head of our legislative system, and she has different duties as a result of that are related to legislative matters. Assignment to committees, really good example.
So
and it's important in assignment of committees, as I understand it, and I'm not a part of the body, but I've been a student of the body, that I'll use the Speaker of the House. The Speaker of the House may want to put somebody in a chair position because they are going to become a kill committee. And speaking a little inside baseball, but you understand the inside baseball, that is part of the legislative process. And that's not happening it's not a vote on the floor. It's making a decision before a committee is even met. It's outside of committee action, but it's part of the job of the Speaker of the House. So I think we have to be really conscious here that we're talking about powers of the leader of the body, which are going to be different, and deciding where somebody sits or deciding where an office space may be, to me, fits within that role for her. Respond to that.
So respectfully, Justice Bacon, the President pro tempore of the Senate does not make Senate appointments unilaterally, and it is decided by the full body of the Senate. It is a committee report that is voted on by the whole Senate and adopted or rejected. And I'll be frank, one of my other allegations is that Senator Stewart removed me from Senate Finance for engaging in my protected activity, but I did not bring that claim. Why? Because that action taken by the whole Senate and the votes of the Senate would very clearly fall within the heartland of the immunity clause. Now, the real question becomes moving an office and moving the seat on the Senate floor. Are those integral to the legislative process is the question at the first step of the analysis I would propose, and it avoids us getting murky between intent and objectivity.
So, Mr. Candelaria, I'm reading from a transcript attached as Exhibit F. to the petition, reading from page 21 of that transcript, it's quoting you.
Oof.
I would respectfully contend factual development is absolutely necessary on that point, because what the evidence will show is that we're legislators in the roundhouse. Where your office is incredibly important. And it is a highly prized and sought after accommodation. And I would say perfect. It matters. It seems to me that Jacob Candelaria is making the statement, and that his statement is saying that your office is integral to the legislative process. Where you sit, where your office is, says Jacob Candelaria, is important and it matters. And it's incredibly important in the legislative process.
So, Your Honor, Chief Justice and Justice Vigil, that inquiry and that evidence is certainly relevant to determine whether or not there was a retaliatory act. I don't believe I was trying to argue there, or I should say my client was trying to argue there, and I'm not trying to argue today that this is evidence that means that the location of the office and the seat are integral, as our federal courts have understood the concept of integral. And
But then why, I'm going to poke on offices again. It seems that the certain committees of the legislature have deemed it integral to have office space that is co-located, chair, vice chair. And we see that all of the time because it's integral to legislative function for the chair to be able to easily speak with the vice chair, and people know where to go to talk to leadership, and it's not running from the annex to talk to the vice chair and then to the main building to talk to the chair. There's a logic to it that is part of the legislative function. And we see that mirrored in the roundhouse all of the time. So why doesn't that give us some sense that it is integral to legislative function?
Because I think what we sense the federal courts grappling with and eventually coming down on the line of saying that not everything that's important or reasonably related or reasonably within the sphere of legislative activity or function is integral. So I think the strongest point I can make here is in the record, which is during the COVID-19 pandemic, the legislature, including the Senate, amended its rules allowing members to participate on floor and in committees and to cast votes and engage in speech or debate from any location within the roundhouse, which I think is very strong evidence that the functioning of this body of government does not depend upon where the office or the seat is. It's not integral. But to your point, Justice Vigil, from a New Mexico Human Rights Act retaliation claim perspective, you have to show retaliatory act. If this court concludes that the action of moving the office, while important, while official, is still not integral, then the claim can move forward. And I have to demonstrate, if I may, I have to demonstrate as part of the prima facie claim that a reasonable person so similarly situated would have been deterred from engaging in similar protected activity because of the actions. So what do I have to show? It mattered.
So if immunity applies, though, whether you can make that showing or not is irrelevant.
Correct.
And let me make another point. I don't mean to interrupt. But
No, certainly.
I remember when the Republican Party took over control of the House under Governor Martinez. And I'll refer specifically to Representative Gail Chasey. Under the Democrats, her seat on the floor was right up front, next to the aisle. When the leadership changed in the election, she was all of a sudden moved to the hinterlands. So would that constitute retaliatory action?
No, Your Honor, because I believe such a claim would fail in the representative's inability to show an unlawful retaliatory intent based upon protected activity. And being a member of another political party is not protected activity, nor are those persons a protected class under the scenario.
Retaliatory because you voted against my bills last session.
But in order to bring the claim at bar, I have to show that Senator Stewart's underlying activity violated the human rights.
But does the district court found in considering whether the retaliatory actions or legislative actions for which defendant would be entitled to absolute legislative immunity, the court finds that it must examine the defendant's motive behind those asserted retaliatory actions. Doesn't that alone make this order problematic? Because
It does.
it does.
It does. And we
Okay.
concur with Judge Ramczyk that what this court should do, if it gets to the point where it's going, I think you could do a lot here. But if you go to the place where you issue a decision that says, what are the appropriate limits of the legislative immunity, the test, you remand and send back. I'm asking not for dismissal, again, because the actions in question here are not integral to the legislative process. And send this case back with an instruction that at step one of the analysis, in considering whether the actions are integral based upon the plain text of the Constitution, based upon history, based upon tradition, and informed by an assessment of federal case law, that the claim can move forward, but that the district court did err when it said that at step one of the analysis it needs to consider the motive and intent. We agree with Judge Ramczyk, Justice Zamora.
But then what's the discovery you're doing? I mean, if we're not, you can't ring the bell, other than in a he said, she said type of way, unless you are doing discovery into the motive and intent of the senator.
So Senator Stewart, like any person, can waive her privilege. The issue as articulated in Gravel and again in Bastion that I would point to is there is a difference, and the speech or debate clause is triggered when there is evidence that touches on the legislative action that is being offered to prove the prima facie case. I would offer that if Senator Stewart chooses as a defense in discovery and on the merits to argue that she took her actions because of some official act for non-discriminatory reason, some official act that is not a legislative act for which she's entitled to immunity, she can certainly waive her privilege.
Yeah, but your
and
discovery requests go far beyond that and they go to motive and intent. That's my problem. So you're saying, oh, the judge got it wrong. We're not looking at motive and intent, but I've seen the requested discovery and it goes to motive and intent. And so I think you're arguing in two different.
Well, if I may, Justice, the reason that we're asking motive and intent is discovery and is in order to rebut any claim by Senator Stewart that her actions were not driven by.
But then
retaliatory
we're
motive.
turning the case law on its head where it says you cannot, period. I mean, the federal case law is very, very clear. We don't care about motive and intent. That's what the federal case law says.
Your Honor, respectfully, I would say that that the proviso as articulated in Bastion makes clear that there's a distinction there. The immunity applies when the evidence must be inquired into in order to establish the prima facie claim. It is not as it pertains to an affirmative defense. She can waive that defense.
What's your end game? What's the relief that you're requesting at this juncture?
At this juncture, an apology for 10 years service to this state and being ignominiously insulted in front of my clients.
That is not a legal remedy.
So money damages at this point, if I'm not going to get that, Your Honor, and I believe that the New Mexico Human Rights Act.
You asked for nominal damages in your complaint.
I believe I asked for money damages, did I not?
I think it's nominal damages.
I apologize, Your Honor.
But I'm asking this with seriousness because if say you were still a member of the body, you'd largely be asking us to move your office and move your seat on the Senate floor. And that is not the role of the judiciary. I think we're very concerned about how far we reach into this as the judiciary.
Your Honor, if all I have are nominal damages, I'll take the $1. What matters to me is that I engaged in protected activity. I called out what I believe to be racist behavior that was perpetrating racial harm. And for that, I was retaliated in ways I did not deserve after 10 years of serving the state. So $1 would be enough. And I will disclaim here in open court any claim for injunctive relief.
I have a question with regard to, again, to go into this question of your, kind of what you're captioning as a prima facie case. Would you like some water?
I apologize.
No, that's okay. It's a lot.
Right.
Please, Mr. Chief.
All right, so, a complainant comes forward with this complaint, a complaint. HRA complaint, is it sufficient for the legislator then to submit an affidavit that says this action, moving an office, moving a chair, was for a legitimate legislative purpose? It was to preserve the decorum of the body, for example. These two legislators are not agreeing. So there's the affidavit. Is there factual inquiry behind that affidavit, or is that the end of the discussion? Because, and the reason I ask this is because part of the concept of this immunity is everything we've discussed, and we just generally don't mess with that branch. Hopefully that branch, although they like to, mess with this branch, right? We don't, these disputes are not invited into our area. That's one of the concepts behind the immunity. And what I struggle with is anything behind looking at this affidavit, if they were to offer this, sends us down that road. And that's why this cloak of immunity doesn't fit well with us, but it is what it is under the federal jurisprudence. It seems to even be applied under Title VII cases.
So in the scenario you've offered, the question for the district court would not be factual inquiry, would be a question of law. It's the same question here. Is the moving of the office a legislative action that's entitled to immunity versus an official act that, while important and very significant, is not?
As a category.
As a category. And that's the first step of the analysis where there's no requirement for it.
So why do I need factual inquiry into that?
You don't.
It is
So
or it
we
isn't.
decide as a matter of law
Yes.
that this was part and parcel of the President Pro Tem's leadership position. The inquiry is in. Ends.
Well,
But that's not entirely satisfactory to us because there are circumstances, I think.
that's why I come back to this ground has been trod for you by Gravel and Bastion that lay out the proper inquiry, which is this integral? And the question is, it's not. And I just come back to the legislature was able to continue conducting committee hearings, having floor debates, conducting votes, while allowing members to be not only anywhere in the Capitol, but anywhere in the state at once. How can something be integral? How could any of that legislative business have happened if the location of the office, the location of the seat is integral? It's important.
This court did not interfere with that rule,
With what rule, Your Honor?
with the rule allowing legislators to meet by video.
Of course.
And there was a writ of prohibition brought, Pirtle, I believe was the name, where there was an attempt to say that that rule was no good. And we expressed serious reservations about interfering with the legislature to operate itself according to its own internal rules. And is not, and along those same lines, is not assignment of office and desk space part of the discharge of official legislative duties of the President Pro Tem.
Well, Your Honor, there's nothing in this record that says that the action that Ms. Stewart took were subject to any sort of Senate rule. Senate Rule 401 and 403 address the power of the Pro Tem when the Senate is convened and meeting, not the power of the Pro Tem when the Senate is not meeting. The designation that Justice Bacon referred to in statute merely designates the President Pro Tem as the co-head of the branch of government for purposes of receiving service only. And the Constitution says very clearly that discipline is not within the power of the Pro Tem as an individual acting in the legislative interim outside of a committee and not pursuant to a legislative committee order, as in the cases where people are executing subpoenas, but acting on her own. This whole Senate did not take this action. And that's what distinguishes this case from the other discipline cases that the petitioner cites to, is in those cases, the actions that were being challenged, the expulsion from caucus, being expelled from the body, et cetera, were taken by the full legislative body in a formal proceeding subject to debate and a formal vote. Here, none of that is present.
So she did not act in the discharge of her official legislative duties.
She may very well have, Your Honor, but that is not dispositive because, again, even though an act is official and important does not mean that it is integral. There is a difference.
Legislative.
It is still a legislative act, but the federal courts have never said, and the court in Gravel specifically rejected many of the arguments that Senator Stewart is advancing today, that the test is one of more reasonable or what's important to the proper functioning. Under that test, they win. But under that test, if the court adopts a more broad view of the scope of legislative immunity, the reverse of that is that people are denied justice for wrongs. And you've addressed today the quid pro quo sexual harassment.
So if the legislature was convened when the office was moved, you believe that she would be entitled to legislative immunity? You made that distinction, so I just want to clarify.
I think that there'd have to be two prerequisites. It would have to be an action of the body. It would have to be some sort of
Ratification of.
motion, some sort of motion or committee report that has been voted on by the Senate. Because what you see animating the federal case law is, again, this direct integral connection to the actual meeting of the Senate, composed of 42 members, to the actual meeting and action of committees.
Additional questions from my colleague? Thank you, Mr. Calloway.
Thank you for your time and your questions.
Mr. Wertheim, you have 7 minutes.
Everybody seems to agree that motive and intent are irrelevant. So do you take a contrary position?
Well, Your Honor, what I am taking the position on, first of all, may it please the court. My name is Stewart. I represent the respondent.
I apologize for my.
No, I apologize for jumping in and violating decorum. What I'm here to do, Judge Ramczyk is not finally judge his case. He is not taken aside. I'm here to defend his order as a whole. I think you need to look at the order as a whole to understand what our real point is, which is this case is not appropriate for extraordinary. It's just not appropriate for the rare superintendent control. And I think the struggle you are having with this very fuzzy line, it's not absolute immunity. It's immunity that at some point bleeds into administrative function. And
I don't think
it's
administrative function is a feature of this. I think the better argument, which your client didn't engage in, is something that is integral versus reasonable.
And let's ask why Judge Ramczyk didn't do that. That's why I said the order has to be defended as a whole and why this case is not appropriate for extraordinary relief. He didn't do that because he did what the petitioner asked. He said, I think there needs to be discovery, but this is a case of first impression. The petitioner said, well, if that's the case, we think it is absolute immunity. We would like an interlocutory appeal. So the order is integral. The district court order that says,
But going to the Court of Appeals before coming to us on the definite, they would have certified this question to us in a nanosecond. So here you are. They're not going to decide the permutation of the boundaries of legislative immunity in the first instance. They're going to send it to us. So I'm not particularly persuaded that this should have gone through some either, normal final order appellate process or through interlock. It was going to end up here, and here we are. So I'm frankly a little kind of frustrated with that. And I'm going to say this out loud because we're on the record. I'm also frustrated that the judge took position in this case at all. I don't think it appropriate when you have two parties that are adversaries to each other and can carry their own water. Saying that out loud for the judge and the judges out there, not directed at you.
I see two pieces of that, and I'm representing and I can respond to that. There was a lot of debate about whether there should take any position. But in defense of Judge Ramczyk and his order, he can't certify. He can't force someone to file an extraordinary right. He has one tool for immediate appellate review under the rules, and maybe that needs.
But I don't think it hamstrings the party's ability to take a different procedural path, knowing in the end, it's going to end up here. We see that regularly, like 4 times a year at this point, where it could have been interlock, it could have been a traditional appeal, but the parties recognize the stakes involved and that it's a constitutional question of great public importance, and they come to us.
Judge Ramczyk nor I, as his lawyer, and this is actually going to be the first part of my opening, let me just say it. He's not judges. He completely understands and respects the idea that this is the earliest moment to decide it. and this may be an issue of great public importance. And this court may want to decide it now. And he is not taking a position on that.
And I just don't see that going to the Court of Appeals would help us address this tension that we're feeling, because they can't answer that for us, because it's for us to resolve.
And that makes it absolutely appropriate for extraordinary relief. Now, I do want to do one last defense based on what I heard here of this order and discovery.
Mr. Wertheim, can I interrupt you, please?
Yes, you may, of course.
If I misunderstood you, did you just say this is an appropriate case for a writ?
I said that it's Judge Ramczyk is not, as a district court judge, going to prejudge that this court would find it appropriate for extraordinary writ relief. We understand that that is the case. Personally, as I look at the law, I think this is more appropriate for a writ of error. I don't think it's any more important, prosecutorial immunity could be very important. It might be very important to Jack Smith very soon in the federal system. Judicial immunity, some of the judges sitting here, many judges around the state who've been sued by unhappy litigants, an issue of great public importance. All of those are reviewed by the writ of error. This court announced that over 20 years ago in Korea versus Rostro. You've decided to delegate that to the Court of Appeals under Rule 12.503. Maybe that you would want to hear that writ of error directly. But this court plainly stated that qualified immunity is decided by the writ of error.
Qualified immunity. If the problem I'm having with the argument that it's not proper for a writ is that, assuming on these facts that President Pro Tem Mimi Stewart has absolute immunity, she should not have to withstand a trial, discovery, and all of that, and a regular appeal, and then an appeal to this court. On the other hand, we could say that it is not appropriate for a writ, or that she's not entitled to absolute immunity, and in which case we'd expeditiously remand for continuation of the process. But if she's immune, she should not have to stand all the aggravation, expense, and everything else that goes along with discovery and trial.
Oh, you're absolutely.
And a writ stops that.
You stated that perfectly, whether it's writ of error or writ of superintending control, you're exactly right. And this court said, following federal precedent in Korea versus Rostro, that's exactly what it is. It's that you should not have the burdens of discovery, but that's the test under qualified immunity. And I would say that despite all this discussion of absolute immunity, this is an absolute immunity. It's qualified immunity. There's a line out there somewhere, right? What did the Supreme Court say? When you publish black kids' test scores in your supervisory role in Congress to humiliate black children in the DC public schools, when you go to the Post to say that, you've crossed out of legislative immunity. Now you're doing something very anathema to your role as a legislature. So there's a line out there somewhere. It's qualified,
But
it's appropriate for writ
nobody
relief.
yet, because nobody yet has given me a principled test. Trial courts to apply when they see this in the first instance. I don't believe that the case that Mr. Candelaria hangs his hat on provides a principled test. It's statements of theory. The federal case law doesn't provide a principled test. And in fact, I think it's kind of at odds with each other. So what's the principled test we would apply to understand what that line is? And nobody's presented that to us. And that's, I've been like graying by the minute thinking about this.
You know, when I say I'm out of time, I answer your questions. You have that test. You've announced it. No one's hit on it, but I'm going to announce. It's the interstitial test under Gomez. There's been lots of discussion about, history, Mr. Candelaria suggested and so forth, but this court has articulated how you decide whether to deviate from federal authority.
Except I think the federal authority is at inherently is at odds with its own discussion of a test. So I'm not adopting any federal test because they're all a hot mess. I can move away from the interstitial approach very quickly. And in fact, I think the interstitial approach is the wrong method for interpretation in the state of New Mexico going forward. I haven't convinced my colleagues of that yet.
Well,
someday I will. But the test articulated in the federal case law doesn't
doesn't help us with this question. So what's the principal test that we're supposed to articulate should this come up in the future? And I just don't know what it is.
Well, all I can say, Your Honor, and if I may respond again beyond my time. The second prong of the interstitial test, then go as just as existing law as a lawyer here, is that the federal analysis is flawed.
But why is it flawed and what test should we adopt?
I'm the one arguing it's flawed.
Oh, well,
And-
that's true. But why, what, if we created a test for New Mexico, what is the test?
For the line between,
Legislative immunity and when it's not available. What would be the standard, the rules that we would provide to district courts to make these decisions going forward? Because we just thought of a million hypotheticals that could fall on either side.
Your Honor, I don't mean to hunt, but I represent the district judge here. And all I can say is I think you see why he struggled and said, "Hey, I want to decide this on summary judgment," after getting a little discovery. And the last thing following on that, if I may, is that Gomez, if that is the only way to go, which it is the existing case law, wherever this court may go in the future or not, Gomez does make it clear that it is the obligation of the parties who are developing the interstitial test to make a record. And that is plain in Gomez. And that militates in favor of discovery. It weighs against, of course, the purpose of immunity. So there's a tension there. But if this court is going to, this is why my last word on extraordinary relief, if this court is going to announce once and for all the contours of legislative immunity, it may not want to do it in this truncated fashion.
Thank you, Mr. Huerta. 3 minutes.
Thank you, Your Honor. In talking about a test that this court could use to instruct the lower courts on how to apply the speech and debate clause, I mean, the test really is this objectively, is the action integral to the legislative process? I think in most cases, it's going to have to be taken on a case-by-case basis. Is it, does it impact the deliberative process? And I think a lot of things will be obvious. Votes, assignment of committee assignments, some of those things will be obvious. But here, it's also obvious that these actions in reassigning a seat on the Senate floor and reallocating office space are objectively legitimate legislative actions.
Mr. Candelaria argues that I hope I don't misrepresent, that it must be somehow endorsed by the body. That is, in fact, it may be that individual legislator's legitimate legislative function, but it is not endorsed by the body. That is not necessarily how I read some of the federal case law, including Youngblood. Can you respond to that? And I apologize if I misrepresented that argument, but that's my understanding.
Yes, and I don't think that is a distinction that has been clearly delineated in the federal precedent, whether it's an action taken by an individual or a group of people or the entire body. And the Youngblood case is that Third Circuit case that does talk about that specific members have specific roles that might be different than the line legislator. And those people in those roles get to allocate. That case was about allocating funding and other resources.
Or office space.
Or office space. Well, office staffing
Mhm.
was at issue in that case. And that was found to be within the realm of legitimate legislative activity where the legislative immunity attaches.
And was there any endorsement of the legislator's action in that case by the body as a whole? Or was it left with that individual legislator in Youngblood?
In that case, I believe it was left with the individual legislator because the House of Representatives, I think it's in Pennsylvania in that case, had allocated that ability to allocate those resources to the Democratic caucus. So even though those were political leaders, where we're not talking about political leaders here, even there, political leaders, they were entitled to legislative immunity for allocation of funds and other resources So it wasn't an action taken by the body. So I don't think that's a distinction when we're talking about Senator Stewart in her role as the president pro tem. She's entitled to take these actions, and there.
So are you, they talked about perhaps creating a different standard or test under the New Mexico Constitution. And from what I'm hearing you, although you haven't explicitly stated, you're asking us to follow federal law?
Yes, Your Honor. Yes. And under federal law, both of these actions are legitimate legislative actions. So we're asking the court to exercise its superintending control to reverse the decision and remand with instructions to the district court to grant the motion to dismiss.
Time is up. Let me check for my colleagues, make sure. Any other questions? Thank you, counsel.
Thank you very much for your.
Matter of S-1-SC-40573, Stewart versus Ramczyk, I apologize. This is matters a writ of superintending control. Court is going to recess. If we are able, after conversation, to reach a decision, we will come out and announce that decision. If we are not able to do so, we will let the clerk's office know and they will discharge you. That means I would like, as much as possible, to parties remain in the courtroom until you get further instructions from the court or the court's clerk. For now, the court is in recess. Good afternoon, you may be seated. Thank you. We are back in the record of Stewart versus Ramczyk, S-1-SC-40573. Counsel parties present in the courtroom. Court has conferenced this matter and is prepared to issue its decision today, followed by written opinion at a later date. In the matter Stewart versus Ramczyk, court concludes as follows. Supreme Court has original jurisdiction pursuant to its authority under Section 3, Article 6, Section 3. Authority is superintending control over the inferior court, which includes control where it's deemed to be in the public interest to settle questions involved at the earliest moment. Kerr versus Parsons, 216 NMSC 028. As to the substance of the dispute, court concludes as follows. Senator Stewart is entitled to absolute immunity for actions integral to a role as president pro tempore of the New Mexico Senate, specifically by reassigning the seat former Senator Jacob Candelaria on the Senate floor and reassigning the location of his office in the state capitol. 2, the district court erred when it denied Senator Stewart's motion to dismiss on grounds of legislative immunity, instead concluding that it would allow discovery into motive and intent into the actions described above. As a remedy, the court will remand this matter to the district court with instructions to dismiss. Apologize for the sun in my face. I'll start with the petition. One moment, please. Start with the petition. Any questions on the court's order? Candelaria. Thank you, Mr. Candelaria. Again, a formal opinion will be issued later. We appreciate the parties' again presentation in this matter. Court is in recess.